docket and general discussion with counsel that Fuqua is anticipating changing his plea this morning.
We're getting copies of the plea agreement at this time. He will plead to count 1 and count 2, vehicular homicide.
Mr. Fuqua, will you stand, please? I have some questions for you. The first question is whether you have any disabilities, either mentally or physically, that prevent you from understanding what we're doing or prevent you from proceeding.
No, sir.
I want you to be assured that you're entitled to have the benefit of qualified attorneys now and at a trial if you choose a trial, and at every important stage of this process, regardless of your ability to pay for an attorney. Do you understand that?
I understand.
When you were here before, we talked about the charges against you, and we also talked about the maximum possible punishment. Do you have any question about any of those things?
No, sir.
If you tell me that you're guilty, you're going to be giving up important rights. So I want to be certain that you've had enough time to talk to Mr. Moog and Mr. Murphy. Have you?
I have.
Have you told them everything that's involved?
To my knowledge, yes, sir.
Are you satisfied with the help they've given you?
Yes, sir.
If you tell me you're guilty, you're going to give up their assistance after this hearing and after sentencing. You're also going to give up your right to have a speedy trial before your choice of a judge or jury. If you chose a jury trial, you'd further be entitled to an instruction that you're presumed innocent, and that the state must prove you're guilty on a reasonable doubt. Do you want to give up those rights?
Yes, sir.
I anticipate, in fact, Ms. Truman has referred to the fact that there's a plea bargain agreement. You need to be aware that that will bind the state, but it does not bind this court. Do you understand that?
Yes, sir.
And what that means is that though there is in essence, a joint recommendation to the court about how you ought to be sentenced, the court need not adhere to it. And further, that as a result, if you plead guilty, and you are then sentenced, and you don't like the way it turns out, you're not going to have any opportunity to change your mind. Do you understand that?
Yes, sir.
Aside from that plea bargain agreement, has anybody threatened you or promised you anything to convince you or persuade you to plead guilty?
No, sir.
I need to ask you about each one of the charges that remain. Count 1 is vehicular homicide while under the influence is a felony. Does that charge have to be pleaded guilty or not?
Guilty.
There is also a second charge, which is the same charge, but is a separate count. The allegations, as you may know, demonstrate, or rather allege, that 2 persons were killed as a result of an accident you were in. Now, after count 2, what is your plea, please? Guilty or not guilty?
Guilty.
Before I can accept that plea, I'm required to find out what it is that you did. Please tell me what makes you guilty of those 2 charges.
I was operating a motor vehicle in Jefferson County in excess of the legal allowed limit of alcohol. And apparently I killed 2 people.
When you say you apparently killed 2 people, do you have any doubt that the state can prove that?
No, sir.
You said that you were operating this vehicle in Jefferson County. Was it on a way of the state open to the public?
Yes, sir.
All right, thank you. You can have a chair if you wish. The court finds that the defendant understands the charges and understands the maximum possible punishment and further understands his rights. He's freely and voluntarily waived his rights in open court with his attorneys present, and on that basis he stands convicted and is guilty of 2 separate counts of vehicular homicide while under the influence. Felonies, each of the charges.